Good afternoon, everyone. Chris Gant Sorensen here with Perry McLennan and, of course, Keely Yates, Director of Marketing, always making all of this happen. And we're glad to be with you again. It's been a couple of weeks. We do have a lot to tell you, and we'll get right to that. If we were seeing you in person, my preferred giveaway to you right now would be a Magic 8 Ball. Because at least with a Magic 8 Ball, you may not know the answers, but they're all in one place. And we cannot cover today in detail all that has come out, telling employers what they must do to prepare their workplaces as best as they can to protect their employees from an outbreak when not one person in the world knows the answer to that question. So instead, what we're going to do is tell you in detail what the agencies most in charge of workplace safety say you must do to prepare your workplace. And the good news is that the same agency that would be in charge of enforcing whether you've done a good job has also said, if you do this, then you get, if you're not a healthcare workplace or a first responder, you will get discretion, their discretion for your good faith efforts in complying. And the other thing is we're going to cover specifically the entities that are charged with telling you what you need to do for workplace safety. And as we do so, I think you'll see a pattern. So at least there'll be some certainty in what you can do in these times. So with that, we'll get started. But Keely's going to send you a poll with a couple of questions, and we'd appreciate if you'd answer. And we're glad to be with you.
Thanks, Chris. We're excited about this new poll feature. I hope everybody can see that up on their screen now. We hope to get some feedback from everybody on the bringing workers back and creating a return to work plan. I think that'll maybe help us a little bit as we go through this presentation on getting a feel for what stage of the process everyone is at this point in time. Welcome and good morning. I'm going to give a little bit of an overview of, well, first of all, I hope everybody's safe and healthy. And I hope that as many of you are returning to business, getting operations back up and running. It looks like we've just gotten at least some of the poll results back in, and it looks like about a quarter of you are already back to work. 60% are bringing back workers in phases, which is consistent with what I've been hearing. And then some are pushing out, another month or beyond, which again is sort of consistent with the feedback that I'm getting from clients and people that I'm talking with. But again, welcome everybody. I hope you find this helpful today. I'm going to start out just giving an overview of the things that we're going to hit on in today's presentation. I'm going to give just a brief update on sort of where we stand from just a big picture standpoint in South Carolina. And then we're going to move on to workplace safety. And, that's going to really be the bulk of today's presentation, because I think that's really at the front of everybody's mind, is worker safety and how do we manage liability if we are opening back up. So Chris is going to spend a great deal of time on this, reviewing the relevant agency guidance that we've received, and covering topics like, do we require employees to wear masks? Do we have to change our office layout to maximize social distancing? All those types of things that you're probably worried about as you return people to the office. And then there's a few other ancillary issues that I'm going to hit on at the end of this. I'm still getting a lot of leave questions from clients. There's still a lot of question marks about FFCRA leave, getting a lot of sort of questionable leave requests from employees. There have been some updates on the unemployment front. We've got a couple updates on the PPP program and how that could impact your hiring plans. And then we'll hit on a couple of things regarding the EEOC and whether any of the actions that you take in your safety plan could lead to discrimination claims or violation of the Americans with Disabilities Act and things like that. So I'll touch on that at the very end. But I'm first going to start here with just a brief update on public health. I think everybody is probably like me, and they're, when there's no sports on television, my television pretty much stays on the news channel. So I imagine that if you're not watching Tiger King or Michael Jordan documentary or something like that, you're probably watching the news. And so this isn't going to surprise any of you, but COVID-19 is obviously still very much a real threat. It's not like we sort of waited for COVID to pass and waited on a vaccine to come back to work. Everybody's returning to work, really, and still pretty much a big threat of infection. It's still pretty bad in South Carolina. Obviously South Carolina has not been impacted in the way New York and Chicago, some other places across the country have, but South Carolina hasn't really bent the curve significantly downward. We're still, if you're following the DHEC reports every day, they're still reporting in the ballpark of 150 to 200 new cases a day and 5 to 15 deaths, new deaths every day. And South Carolina is one of the states that has the least amount of testing. So we're still not quite sure how bad it is in South Carolina, but policymakers, and I think probably legitimately in most cases have made the decision that we need to get people back to work. So that's what we're doing. As of, I guess, this coming Monday, basically all businesses in South Carolina will be able to be open in some capacity. Some of you all, because I know everybody's been wanting to get back out to eat, some of you have probably seen the restrictions that have been placed on restaurants as far as occupancy and things like that. There's still restrictions on retail and things. So depending upon your particular industry, you could be opening under more limited restrictions. If you're returning to an office environment, you may not have any South Carolina mandated restrictions from the governor on how you return. But I think I mentioned this in the last presentation that we did. I think the primary thing to keep in mind for you as HR professionals is that we're not returning to a pre-COVID workplace or a pre-COVID world. If health experts are correct, this is going to continue for the rest of the summer. Most health experts are expecting a resurgence in the fall. And an aggressive timeline for a vaccine is probably early 2021. So I say that to say that the safety plans and protocols that we're going to discuss today, need to be taken seriously. And I think there needs to be some real care and thought put into them because they're probably going to be in place for quite a while. And this is something that businesses, I think the term new normal is overused, but we're certainly in some kind of new workplace environment, whatever you want to call that. So I think businesses need to be prepared, and that's one of the things that we'll talk about today. Obviously, worker safety, and making sure that you've got PPE and things like that is important, but there's all these different issues as well on employee leave requests. How do you interact with the public if you're a customer-facing organization? What do you require of your customers? Do you limit occupancy? Do you require customers to wear masks? All of those things are important considerations, which we'll discuss at length today. So just a couple more things on where things stand right now. You know, even though many businesses are reopening, demand is down across a lot of businesses. We represent a lot of manufacturers, and I'm hearing from a lot of my manufacturing clients that supply chains are just interrupted, you know, orders are down, things like that. You know, customer demand to go eat in restaurants and go to, you know, bank lobbies and things like that is probably going to be suppressed for the next few months, which in some ways is good. I think it's going to allow businesses to sort of implement social distancing naturally because of the decreased demand. So I think that is good. I think there's probably going to be an increase in telephone calls and electronic transactions and communication. So you may have to shift your business model to dealing with that a little bit. I've got a link on the bottom of this slide that we're looking at here for the Accelerate SC Task Force. This is the task force that Governor McMaster put together, and it's a helpful website just to get a sense of what South Carolina is doing as we reopen our businesses. I've been serving on the state chamber task force, which has been advising policymakers in South Carolina on what we need for businesses to return. So things like making sure employment claims are covered under workers' comp laws, making sure, you know, people aren't allowed to stay out on unemployment if they're given a job offer, those types of things. But the Accelerate SC website is a good place to track a lot of these developments. And I already see, I probably should have mentioned this at the top, I already see a question there in the question box. For those of you who attend these regularly with us, you'll know that we will try, even though we have a ton of information to get through today, we're going to try to reserve some time at the end for questions. So feel free to ask them in the Q&A box. And we may, while the other person's talking, try to, you know, address them by typing in the box. And if not, we'll address them at the end. Okay, let's talk about workplace safety. Again, this is front of everybody's mind. Before I turn it over to Chris on sort of nitty gritty, I'm going to give you sort of a big picture workplace perspective that I think is important to keep in mind because there's going to be a lot of information thrown at you in regards to what to do. And so here's a couple of general principles. There are very few mandates out there right now. I'm getting a lot of questions from clients, friends, you know, whoever that, you know, am I required to make my employees wear masks? Do we have to check employees' temperatures? Do we have to do this, have to do that? There's very little, you must do this and you have to do this. And if you do this, you will be safe. Most of the government regulatory agencies are very hesitant to put specific mandates on businesses. And the reason for that is that every business is different, every industry is different. It would almost be impossible to do that. And basically, they're, you know, in the free market system, they're leaving it up to most business owners to, you know, make a decision on what safety protocols that, you know, they need to implement for their workplace. There's a lot of information online. You can definitely overwhelm yourself by Googling, and that's one of the things that we're going to try to do today is make this as simple as possible. But three major sources that you can generally rely on and that you should rely on when you create your written safety plan. And that is CDC, which is the Center for Disease Control. They have a helpful website. It's got a lot of information on it, but it is helpful. OSHA, which is the Federal Occupational Safety and Health Administration. Most of you are familiar with the OSHA laws. They govern the safety of the workplace for employees. And then DHEC, South Carolina DHEC, which is our state health agency here in South Carolina. DHEC doesn't have quite as much information. I mean, DHEC it's got some good information about tracking cases in South Carolina and looking at counties and health statistics and all that kind of stuff, but they don't have as much guidance for businesses. They're going to really be making reference to OSHA and CDC, which are the two primary agencies that we're going to be talking about. The major topics that you certainly need to be thinking about are personal protective equipment, both for employees and customers, social distancing with your workforce and their interaction with customers and or third parties on premises, and finally, screening and testing of your employees. And sort of folded within that, I think, are protocols for sending employees home if they've got symptoms, addressing a confirmed case, all that kind of stuff I kind of consider as part of sort of the general screening testing mechanisms that you need to put into place. I mentioned that we're not returning to a pre-COVID workplace, so the worst thing you can do is just act as if it's business as usual. It is not business as usual. You need to create a written safety plan. That is sort of minimum requirement for me on something that you've got to do as you return your employees back to work. You've got to create a safety plan and implement safety protocols that specifically deal with COVID. And so we'll talk about what you need to consider in putting those into place today. And the poll results showed that some of you already have those in place, which is great. Hopefully you'll maybe learn something new today that you can put in those. Many are in the process of working on them, which is perfect. This will be timely. And a few of you indicated that you sort of haven't done that or are not in the process of doing it. And if you fall within that bucket, I would strongly encourage you, if you take anything away from this presentation today, that you need a written safety plan in place. So with that being said, workplace liability for workplace safety is at the front of everybody's mind. Everyone's concerned about employee health, obviously, and the spread of the virus, but I would say the second concern behind that is, am I going to get sued for reopening because of not taking adequate precautions? And so this, I want to spend just a couple minutes talking about liability in general. There are proposals in South Carolina. The state chamber has recommended, and I think other groups are recommending to legislators in South Carolina, and even at the federal government level, I think, recommending that there be laws passed to protect employers that are reopening during COVID from liability just because of the fact that they reopened. So liability from third parties claiming that they went to your business and got infected with COVID. That should not be a viable claim. I mean, there should be, if you're going to a business, if you're going to the movie theater during COVID-19, you're kind of assuming the risk that you're going to get infected if you're going out in the public that way. And so there are efforts for policymakers to make this clear. With that being said, until that happens, we've got to rely on sort of what the existing state of the law is. And as I mentioned at the top, although most CDC, OSHA, and DHEC guidance are, quote unquote, guidelines and recommendations, best practice is to follow that guidance as closely as possible. So if CDC guidance is to maintain 6 feet of distance for your employees in your workplace, do that if at all possible. If they recommend you limit occupancy to 50% of, what the fire marshal allows, do that as closely as possible. Following those guidelines as closely as possible and your written safety plan is going to make sure that you're avoiding negligence lawsuits. So negligence law, many of you are probably familiar with, but it's a legal theory that basically asserts that a business failed to act reasonably under the circumstances, or failed to sort of act carefully or implement necessary protocols and procedures to protect someone from harm. And these would be claims from someone, particularly a third party, that your business was not safe enough. And they contracted COVID because you did not take necessary precautions to make sure that when I went to your business, or if I'm a contractor or a vendor or whatever the case may be, there weren't adequate protocols in place. And those are the types of third-party lawsuits that you could see. There have been a lot of questions about, employees contracting COVID at work. Under current workers' compensation laws, if an employee contracts COVID at work or suspects that they have, that should be a covered claim under workers' compensation if the claimant can prove that it was, work related. And overall, that's a good thing because, as most of you know, workers' comp is an exclusive remedy for employees. So if they can recover under workers' comp, they cannot go to court and sue you for negligence. So that's a good thing. Obviously, if you receive a bunch of claims, that could impact your insurance rating, but that's better than facing liability from your employees in court for negligence. And there are also, again, recommendations to policymakers to make it clear that these types of claims are covered under workers' comp, and also some calls, although I don't think it's very likely, to regulate how workers' comp insurance companies can adjust your ratings and your premiums based upon the claims that you have due to COVID-19. The last slide, and then I'll turn it over to Chris. And I've already mentioned some of this, and I want to move on because I know we have a lot to cover. But OSHA does require that you create a written safety plan, a protocol for bringing everyone back to the workplace, and for what the workplace is going to look like for the foreseeable future. So again, one thing to take away: you need a written plan. That plan, you need to review relevant OSHA, CDC, and DHEC guidelines and tailor that guidance to your specific business. That is going to be the best way that you can protect yourself from any liability. You've got to create procedures for employees to report workplace safety issues. OSHA is already reporting that they're receiving a lot of employee complaints. You want employees and customers to come to you if they see a safety issue. You don't want their first place to go to file an OSHA complaint. So, workers and customers should be very comfortable and should have a very easy process for notifying somebody, hey, this is not adequately social distance, or so-and-so is not wearing a mask, or, whatever the case may be. So with that, I'll go ahead and turn it over to Chris.
Thank you, Perry. All right, so I am going to cover in detail a part of the CDC guidelines and then all of the OSHA COVID-19 guideline. Although when I say all, I would strongly recommend that you yourself review the OSHA COVID-19 guideline as well as the CDC guidelines. The CDC guidelines are pretty easy to go through, and you can use the OSHA COVID-19 document as a step-by-step guide for what you need to do, and then later what your written plan looks like. And so I'd highly encourage you to do that, and I'll explain more about why that is as I go through. CDC in May issued updated and new resources, particularly 2 of them. And as with any item, any resource that we're referencing that I'm doing now, we're going to give you the links throughout the PowerPoint and also at the end of the PowerPoint. And I would encourage you to access those and check this stuff out for yourself so that you're informed. The first thing I'm going to go through would be the interim guidance for businesses and employers responding to COVID-19. This was first issued March 21. It was updated last week, May 6th. And then I'm going to give you the reference to topical FAQs for businesses and employers. It is a great resource. It will answer questions that are coming up in general categories and then specific questions that are usually coming up in those categories. It's very useful. The interim guidance, it just simply requires employers to consider how best to decrease the spread of COVID-19 and lower the impact in their workplace. And the things that the CDC says that employers should consider are preventing and reducing transmission among the employees, maintaining healthy business operations, and maintaining a healthy work environment. I am going to spend time on prevent and reduce transmission among employees, because that is the thing that workers or employers need to be doing now to figure out what they need to do. And I would encourage you to review all of the items and maintain healthy business operations and maintain healthy work environment. Those particularly deal with keeping your business going, things you need to do to plan for absences and the like, as well as policies you need to issue. And I know a number of you have already issued policies that will be discussed in some of those sections. So on prevention, and a lot of you are already doing this, for those of you who are still operational, and a lot of you already have written plans that say this, but if you don't, then you do need the written plan that says this to your employees, and you need to be doing these things. You want to actively encourage sick employees to stay home. For prevention, you want to consider some tools. First of all, daily in-person or virtual health checks. There's a bunch of dispute about that, and we'll talk about that in the OSHA guidance as well. Do you do temperature screenings? Do you do daily inquiry forms? And I think that depends on what type of workplace you have. Maintain social distancing. So a lot of employers have tape that they've put down. You can see it when you now go to places where like, for instance, when I went to the grocery store the other day, there was tape. They were controlling how many people were allowed in. And when you stood in line to wait to go in, then there was tape about standing in line. Think in terms of that. What sorts of protections can you put up? Plastic guards and the like, screens to protect your employees. What PPE do your employees need to wear? And then which employees can maintain social distance and which cannot, and what additional PPE is needed and what other controls are needed for those that can't. Enforce the maintaining of the social distancing too. That's very important. If you have a policy and you don't follow it, you all know what that looks like. And in this instance, you're more likely to get more employee complaints about that than you would other policies. If you are going to do health checks, make sure that you're following the EEOC guidance regarding health checks, which you can and can't do. And that's referenced, and we'll discuss a little bit more in detail later. And keep the screenings as private as possible, because you've still got to comply with HIPAA and protecting private health information. Look at the workplace. Think about how your work gets done and identify where workers may be exposed to workplace hazards. The first and most important thing, and we talked about this before, and I'll talk about it again, are what sort of environmental and operational and administrative protections can you put into place to protect the workplace and make it better overall. Even if you already have these in place, how can you improve them? Then you get into the individual employee and the individual position. What PPE is needed? You can encourage all of the employees to wear cloth face coverings. Some employers are requiring it. That was one of the questions that was just asked. And then make sure you're posting CDC guidelines in your policies, as well as posting them for your employees to see, as well as your visitors to see. Next slide, Keely. Plan on how you're going to separate sick employees. When you have someone who comes down with symptoms that may or may not be COVID, how are you going to separate them and then exit them from the building as quickly and as safely as possible? And we'll talk more about what that looks like. The CDC also says that you need to, if someone has been sick in the workplace less than 7 days, in less than 7 days, you need to shut down the area where the employee was and where the employee went. So there you're doing the tracing of where all did you go. You're having those discussions with the employee. And CDC recommends that you wait 24 hours and let the space air out, or as long as you can, before you begin cleaning and disinfecting. And then when you clean and disinfect, do so by the CDC guidelines. Next slide, Keely. Also, when you're dealing with a sick employee, take the time to determine which employees may have been exposed by talking to the sick employee, and then in your mind just retracing the normal steps that your employees make in your office, because a lot of the things that employees, all of us do, is sort of second nature, and we don't necessarily know every single place we went, especially if we're an employee who's up and about and moving through the workspace a good bit. And so think in terms of common areas and the like, and what you need to do to disinfect. In regards to communications with other employees who may have been exposed to an employee who could possibly have COVID or who does have COVID, you need to tell them that they have been possibly subjected to an exposure. You cannot tell them who, according to the EEOC and HIPAA. And CDC recommends that you instruct them to stay home for 14 days. In that scenario, you probably need to think about that being paid leave. Is this leave that it is covered under the FFCRA, but is it leave that is that something that the employee should be required to use at that time? That's going to be an analysis for every single workplace based upon resources available, but it's something to consider when you are putting together this policy. Critical infrastructure workplaces have additional and specific CDC recommendations in regards to sickness on site. And so be aware and know that you need to follow those. Educate and you remind your employees about the CDC hygiene practices that most workplaces, I believe, have already implemented, were implemented early March. And make sure you're including mandatory reporting requirements from your employees as to what needs to be reported to them so that you can discern whether or not someone needs to be quarantined. Next slide, Keely. Implement flexible sick and supporting leave documents, and the rest of the information here is going to be the other topical areas. The CDC details in regards to those areas can be accessed at the link I've provided there, and it's also at the end of the guidance or the PowerPoint. And we will be issuing a white paper that has this information in it either later today or tomorrow on our blog. So the other thing that the CDC issued is the topical FAQ, and this is a great resource. The topics are reducing the spread of COVID, and it's specific issues that are going to come up. It's going to give you great guidance on some more specific issues: healthy business operations, cleaning and disinfecting, and special protections for employees from customers and visitors. So be sure to check both of these out. And now we'll slide on to specifically OSHA. Oh, sorry, DHEC. And I will tell you, DHEC says follow CDC. So in regards to DHEC, know that for workplaces, you're supposed to follow the CDC. And we'll be heading on to OSHA. Oh, I'm sorry. I am all about OSHA today. No, let's pop back to DHEC. I'm just all about OSHA today, aren't I? Can you go back one? Thank you. We have gotten this question a good bit, and does an employer have a duty to report to DHEC if one of the employees working for the employer has either been diagnosed with COVID-19 or has told the employer, I have COVID-19? Our advice now is no. Our advice is, unless you are a healthcare provider and you also treat your employee, you are not required to report an exposure to DHEC. You are required to report it to OSHA, and we'll talk about that in a little bit, but you're not required to report it to DHEC. Now, I'll tell you something that's interesting. If you look at the initial CDC guidance that was proposed to the White House administration, that was not ultimately adopted, and nor is it included in the most recent information we have from the CDC for businesses. Initially, the CDC wanted employers to have to report that, and I'm relieved that that's not ultimately what was included in their guidance, simply because, as we all know, that could violate the ADA and HIPAA, and so it put employers yet again in an uncomfortable position. As we note here about the customers, if you have customers that are exposed, that's going to fall under usually negligence, and so you would want to get advice and counsel about that eventuality. All right, so on to OSHA. Perry noted this, and he's right, that OSHA's COVID-19 guidelines are not requirements, they're not standards. And you hear a lot of folks saying that. But I think it's important to understand the distinction. They are not requirements, however, they are guidelines. And they help illustrate an employer's obligation under a standard that requires employers to provide their employees with a workplace of employment free from recognized hazards that are causing or likely to cause the death or serious physical harm. So I think it can be very distracting if employers get involved in the thinking that this is not a requirement, it is not a standard, therefore I don't have to follow it. Because if OSHA is there inspecting whether or not an employer did what they should have done to protect their employees from exposure, they're going to be looking at the COVID-19 guidance. And that is the best information you have to date to follow to determine what you need to do to protect your workers. And more importantly, OSHA has also said that if you follow this guidance, you are going to be given the benefit of good faith discretion, even if you did something wrong. To avoid a violation, employers will receive discretion in any analysis that OSHA performs on their workplace if you had good faith efforts that are evidenced by following OSHA's COVID-19 guidance. And so that's the importance of it. And that's why OSHA gives you this information in this situation that you can follow as a step-by-step guide. And it not only is the best way, the only way that is really out there to protect your employees. In fact, the CDC references it all the way through its guidance. You'll see that. But it's also the best way to protect your employer, your company legally. Note this, the most likely visit from the South Carolina Department of Labor Licensing and Regulation is, and that's the agency that will hear complaints, whistleblowing complaints, and also that's the agency where, you know, OSHA is going to be coming from that agency, so they're going to be responding to complaints. The most likely way that they're going to get involved in an employer's protection efforts is if an employee has complained. And employees are complaining because they're scared. And so already, this was an article in the Post and Courier, 300 complaints have been filed with OSHA as of this article's date. 135 were formal complaints. Most of them are complaints from employees, inadequate PPE, and employees who were reporting to work with symptoms of COVID-19. From those complaints, 99 investigations had already been instigated by the time the article was written. And so this is another call to arms to make sure that employers are putting in place protections outlined in OSHA's COVID-19 standard. Next slide. The most important thing that OSHA says employers can do is look at engineering controls that they can implement. And even if you have these in place already, because sometimes that is what I hear back, are there ways you can increase ventilation and increase airflow? Look for situations like that. Look for common ingress and egress. Are there places where you can safely and not in violation of your security measures that you're required by your industry to have, leave doors open? Do you need to put physical barriers such as plastic sneeze guards up? You know, you've all seen those if you've gone to the grocery store. And if you have them, make sure they're rounded and that they actually protect where they need to. Make sure these would actually protect employees. Look at it as an OSHA inspector would. Visitors should be excluded according to OSHA, but if you cannot exclude visitors, and of course many of you cannot, then try to restrict them to specific locations and require them to complete the same daily inquiry forms that we're recommending you use for your other employees. Next slide. Also, in regards to visitors, if they do have to be on site with your employees, and many of you work that way, then you need to make sure they're using the proper PPE, And you can't just assume, legally, I would not just assume that that would be up to their employer, their contractor, because again, you have an obligation to protect your own employees. In regards to employees, can you create staggered shifts? Does everybody need to be at work? Can some people be teleworking and the others that have to be at work for the critical infrastructure of the business, they can be at work? That gives them more space, and you're decreasing interaction from employees, and then by definition, hopefully better able to achieve social distancing or even greater distance among the employees who have to be on site. What if, and we say non-essential, I'm sorry, I wasn't done with that slide. Please back up. Thank you. We tried to do the slides ourselves last time and that didn't work so well, so thank you. When it says non-essential employees, there are really no non-essential employees in South Carolina. Everybody's essential. So, but these are the employees that could possibly telework. If they have to come in, can you have them report to the office only when they need to? Can you, as the employer, structure when they're allowed to come in? When you have essential employees, and that just really means critical infrastructure employees here on site to keep the business going, can you do some things that would require them to also stay in the workplace, in the area in the workplace where they need to do their duties, and restrict their movement beyond that area unless it's required to perform an employment duty? In other words, don't go visiting everybody. This isn't time for social interaction, that sort of thing. Think about things like that. Can you restrict access to the facilities by anyone other than those required to be present for work, such as denying visitors except for those that are required for you to perform your work? Whatever you decide to do, disseminate what you're going to do and get employee input. Just like you would with the job description, there's how you think it goes and there's how it really goes. Get their input, get their buy-in. That also may help deal with some of the anxiety that they're having about returning. Next slide. Exposure controls. This is where you begin looking at, besides just what the workplace is, how work gets done, the specific job and how that's being carried out. And OSHA has designated 4 different risk categories for you to consider in determining what protections are necessary for your employees. So what you should do is go through the 4 risk categories, figure out which one applies to every single job description you have, and then determine what PPE you need. And OSHA's even made some good, some good charts for that, as has CDC. So consider that, consider where they fall into, and then figure out what PPE is needed to protect those employees in each of the job descriptions. Also, determine what do you need to do even if we have customer or other worker involvement. How can we minimize that? How can we control it? How can we best protect employees in that? By signage, tape, social distancing. There's all sorts of measures that are available to employers and that employers themselves may come up with to best protect the employees. Next slide. The 4 risk categories are very high exposure, medium exposure, and lower risk. And in those risk categories in the OSHA COVID-19 guidance, they even have specific categories that they have already determined, specific jobs, they've already determined where they fall. In addition, OSHA on its website has industry-specific guidance for a number of industries where OSHA has decided which categories these employees fall in. And so it's important for you to know that and to access it. All of that information and those resources are in these slides, and they will be in our white paper. Then ask yourself, how can we change how work is performed? Can we stagger shifts? Do we need to have 2 shifts? And I know that's an operational pull. These are just examples. Less people on shift. Are there other spaces that we're not using in the workplace that we can have work being performed? Are there ways for us to put in cubicles or barriers that we didn't historically have to better protect? These are the types of things that you can be thinking about. Always remember, everything you do, you need to be able to prove you did it. Go back to the previous slide. Sorry, y'all. Be able to prove that all the efforts that you undertook are being undertaken. So the worst thing can happen, and this does happen, when you've done all of this, you've put it all in place, but you haven't documented what you've done and you're not able to prove it. And we all know we've been involved in situations like that. And that scenario, the agency will look to you to see what you've done. So be sure you can show it to them every single step, including pictures if that's appropriate, a written plan with pictures, whatever you need to do, but make sure you're documenting what you're doing. All right, next slide. All right, PPP. OSHA indicates what PPE is needed for which specific situation. It gives you examples of PPE. This is not new. This is the same standards. These are the same standards that have always applied to these PPEs. OSHA has, however, issued in the last 6 weeks 5 different guidances, all enforced and applicable to respiratory protection. So if you are an employer who uses any respiratory protection, make sure you're following that. And again, it's in the slides. If you're issuing PPE, you've got to make sure that employees know how to use it, store it, and clean it. And you've got to train them on how to wear it and all of these, the storage requirements and the cleaning requirements. You want to make sure that that's also written down in your policy. Next slide. The temporary enforcement guidance that was issued on April 13 said that OSHA will also be determining if there are high-risk employees in the workplace and what sort of things are you doing to protect them. Now, this is tough because the EEOC said you're not supposed to ask your employees about any underlying conditions that they may have when you're doing your screening. And also, you're not allowed to ask employees their age if you don't already know it. Nor would we recommend that you approach anybody and have discussions with them, although the CDC does require, the CDC does suggest that. My recommendation and our recommendation is instead you put this in your policy, and like any other ADA criteria, you list the specific CDC high risk and you ask people to come to HR and let them know if any of these apply to you and if you believe you need any additional protections. You can also identify opportunities for people who fall into these categories to work positions in the way that they are maintaining social distance and other protections you could put in place for them if this comes up. Next slide. Visitors, we've talked about visitors. Restrict, screen, limit to specific areas, try to keep the distance. If not, give them the same PPE that everybody else is getting or require them to bring their own. Next slide. Additional prevention measures. Like I said, there are greater prevention measures for specific industries such as healthcare workers, dentists, first responders, mortuaries, a number of them. Then make sure your policy has something about safe work practices. And these that you've seen before are washing your hands, hygiene practices, using the hand sanitizer. Make sure that you're providing hand sanitizer that meets the CDC requirements. Have some no-touch trash cans and tissues around, and follow the regular cleaning and disinfection recommendations that the CDC recommends. Next slide. Daily screening. There's a lot of discussion about that, and I think each employer is different. You can do written daily screening forms where you ask the employees and visitors if they've had any of the current CDC symptoms, if they've traveled to any hotspot places, or if they've traveled anywhere, or if they reside with anybody who's been to hotspot places, or with anybody who has been exposed to or diagnosed with COVID. This can be written. You can also do temperature checks. There are very specific guidelines from CDC about the process for temperature checks, and then you would also want to follow EEOC's guidance for how you do the temperature checks if you decide you're going to do that. Next slide. Written policies. We've said that a good bit, so make sure you have written policies that detail everything we've just discussed. And make sure that your policies have the reporting requirements so that you know who you need to quarantine. And then finally, as we've said, make sure after you do all of this that you're documenting everything you've done in a document that outlines all the protections, which would of course be different than the policy you issue to your employees. Next slide. You do need to come up with, as part of your process, a means to isolate infectious individuals. You need to be able to isolate them and exit them from the building. And the CDC outlines what sorts of protections need to be available and used by the employee who is charged with carrying out the isolation and exiting, as well as the types of questions that need to be asked. So you need to have a space that is available in your workplace for isolating ill individuals. And it needs to be a separate space from those who have COVID-19. Now that's in the requirements. And I think that's an interesting requirement, since how do we know who has COVID-19 or not? So I guess the answer to this is that wherever you're isolating people, make sure that they're as far away from anybody else who is in the room that is also being isolated. Maybe you come up with a different process depending on what your workplace is like as far as how you handle it, so that you don't have to run the risk of determining whether or not on a day you were isolating several people, all of them or one of them had COVID. So again, that's going to be a workplace by workplace analysis. Next slide. OSHA reporting. These are the requirements for OSHA reporting, and on the Form 300, it was updated that if you have an employee who has been diagnosed with COVID-19 and they contracted it at work, you must report it. There are very detailed guidelines in OSHA's regulations about whether or not something is work-related, and I would encourage you to check those out. There's also a chart that you can use to help inform your decision that is moderately more informative. But in the end, if you are not a healthcare worker or first responder, you are just probably not going to know whether a worker has been exposed to COVID-19 on your workplace. And so treat it like you do every other workers' comp measure, besides following all of these guidelines that we've just outlined, and fill out your first injury report. Next slide. You have reporting requirements to OSHA as well, as far as how quickly you need to call OSHA and report that something has happened. And those are outlined here. We've discussed those before. Fatalities within 8 hours, inpatient hospitalizations within 24 hours, and the time period you have to respond to written request. Our advice is always, if you're responding to a written request, please get a lawyer involved so that you are responding in a way that won't make things more difficult for you, because OSHA will use your responses to consider any additional investigations for a year. Next slide. Okay, so just go ahead and pop through these next 3 slides, but you can see these references and they will be in our white paper. Go ahead, next slide, and then next slide. We have them categorized by category. All right, the EEOC, really quickly, the EEOC has pandemic guidelines. They were issued in 2009 and they've been updated for COVID-19. They're linked at the bottom here in our blog on it. And specifically, the EEOC says you're not going to violate the ADA if you do temperature checks or ask employees daily about their possible symptoms. That's not considered an ADA violation, especially if you do it with everybody. You cannot, however, inquire about underlying conditions. If you do temperature checks, you're going to need to do it in a way that's best protective of the employee's confidentiality, which means you need to do it privately, and you need to do it in a way that's not visible to everyone else if someone has a fever that would require them to be sent home. You need to think about exit, ingress, and egress for where you're doing the temperature checks, and do all you can to maintain the privacy. If you're having employees fill out forms, they need to be done in a way that the employee can keep the information that's on the form private, and that you, once it's given to the employer, will also be able to do so. So that if you have someone taking in this information, you need to think through how we can maintain the ADA confidentiality requirements about the information that's on the form until you can get it in the HR office and into the personnel files. The EEOC does say that employees are entitled to exemptions from vaccinations. So when vaccinations do come out, there may be some issues there. Of course, there are always going to be exceptions where there is a more prevailing reason that a business would require that, just like there are exceptions to other vaccinations that certain employers must require. Next slide. All right, the Department of Labor updated the FFCRA FAQs, and I'm going to cover those pretty quickly because they don't really change that much from what was already required. But by now, the FAQs on FFCRA are in the 90s, so it is probably a good idea to scroll through those as well so that you're staying up to date with those. One of the questions that they updated are about temporary staffing employees, and if the temporary staffing company is over 500 employees, but the joint employer, the potential joint employer, the business that they're assigned to is under 500, is that employee entitled to FFCRA leave? And the answer is, if it meets the joint employer standard, then the employer who's under 500 does have to give the employee FFCRA leave. Teleworking employees, those who've been teleworking for a period of time, the question was, are they eligible for FFCRA leave? And the answer is yes, they are. Even though initially they were able to telework, there may be some reason why they're no longer able to telework. So here's the information in the FFCRA that allows you to ask for updated information from them to verify that they do need FFCRA leave because they are currently not able to telework. Next slide. In regards to the second reason for EPSL, emergency paid sick leave under the FFCRA, which is I have symptoms of COVID. The final rule is clear about what an employee has to provide for it to qualify, and it is specifically the name of the doctor and the date that they're getting treatment. That's all they have to provide. The EEOC just says that you can ask for a doctor's note, but the FFCRA guidance from the Department of Labor says it's minimal documentation is required, since the whole reason behind sending these folks home and giving them the leave is to slow the spread of COVID-19. Summer child care, that's a question that we're getting a lot. Employees had to have child care available for the children once school is out, even before COVID-19. So the inquiry there is, have they not been able to obtain that or participate in whatever their plans were for the children that summer because of COVID-19? So that's what you'll need to discern. What were their plans, and is COVID-19 the reason they no longer exist? Next slide. And I'm going to hit this really fast, and I've got to give it back to Perry. I know I've taken up a good bit of time covering that. I think a lot of employers were scrambling and maybe not in a position to oppose unemployment claims that shouldn't be paid. But the truth is, just like in 2008 and 2009, when we had that downturn in business, DO had to come back and implement measures that were greater experience ratings that employers were required to pay for claims that weren't worthy or that they didn't fight. And so fight the claims. When it doesn't apply, you need to fight the employment claims so that you can protect your experience rating for what may come down the pipeline later. And DO said as much. So here are resources from DO about how you can communicate to DO if there is an employee applying for unemployment who shouldn't be receiving it. I've gotten all kinds of crazy questions. I have one employer who's been paying an employee to stay home. Their job is not one that they can come and do. And so they're being paid their full salary to sit home, and they still filed an unemployment claim. So fight all of this. Check out these resources. All right, next slide. All right, back to you, Perry.
Sure, thanks. And I know, thanks, Chris, that's helpful information. I know it's a lot of information for many of you. We've had quite a few questions in the Q&A, Chris, while you were talking. I've answered many of them, but there's a couple still hanging out. Kevin, I have not been ignoring your question, which was asked earlier, but I'm not a HIPAA guru by any means. So that's the reason I haven't been answering your questions. We do have some healthcare regulatory lawyers here that are more in tune with all of the HIPAA requirements. And I'm very happy to ask, to get to ask them those questions and not have to learn it myself. And then Sarah and others will get to your questions. And I know it is 1 o'clock. So obviously if you've got to jump off, go for it. I'll address the last couple of topics, some of which Chris already touched on as well. Employee leave requests, I'm still getting a lot of, and I think it sounds like Chris is as well. I think that's going to continue probably for the rest of the year. The FFCRA by its terms applies through the rest of the calendar year through December 31st. So you're going to probably be dealing with FFCRA issues the rest of this calendar year at least. I would not at all be surprised if there was some push by Congress to extend that, depending on how the virus plays out through the rest of the year. So keep that in mind. There's also, if you've been following the news, the House Democrats in Congress proposed a massive new stimulus plan yesterday, which I think has little chance of passing the Republican-led U.S. Senate, but could be passed in some form. Actually extends the federal unemployment benefits past July 31st, I think, through the end of the year for that. And so, as most of you know, that $600 per week additional benefit that workers are getting right now on unemployment is set to expire at the end of July. I know there's been a lot of concerns about employees wanting to stay out on unemployment, and some businesses were hoping that increased federal benefit was going to go away at the end of July. That kind of remains to be seen, and I think it's going to really depend upon economic circumstances between now and the end of July. I think, from a big picture perspective, and clients, and businesses sort of hate this answer, but I think leave requests are just going to have to be considered on an individual case by case basis. There's a lot of issues at play right now when an employee is being asked for time off. There always is under normal times. Does the FMLA apply? Do they have any company benefits they can use? Are they eligible for workers' comp or short-term disability? All of those issues that you normally apply, add 3 or 4 more levels of complexity to it. And you've got sort of how we have to analyze employee leave requests right now. And so I carefully consider them before just sort of off the cuff responding. As a general rule, because I get a lot of questions about this, employees, can't just refuse to come to work because they're quote unquote not comfortable or scared because of COVID. There are caveats and exceptions to that, but that's kind of the general starting place. If you've got a 23-year-old, otherwise healthy employee who's exhibiting no symptoms, who just says, you know what, I know you're opening business back, but I'm not comfortable yet. I don't think you should open business back. That person generally can't refuse to come to work. And if they do, then you can enforce, generally speaking, your attendance policies as you would normally, grant an unpaid leave of absence or allow them to use company time off benefits if you'd like, those types of things. So generally speaking, you can require employees to come back to work. In the next slide, we'll talk about a couple of exceptions to that rule. The first big exception is under OSHA. OSHA's got something that I'm sort of calling the imminent danger rule, which is basically that you can't put employees in what they call imminent danger. And so under normal circumstances, this can be fairly obvious. You can't, ask an employee to, go fix, something in a manufacturing facility with a, hot wire without adequate protective equipment on, that would be putting an employee in harm's way. We don't exactly know what imminent danger means for purposes of COVID. But what I've been advising clients is that if you've got an employee who says they're not comfortable coming to work, ask them what the reason is for that. Is it just that they're not comfortable, or, are they more at risk? Is this an elderly employee? Is this an employee who's got autoimmune issues? You certainly don't want to be requiring somebody to come to work who you're really putting in harm's way if they get infected. So keep in mind that we're not really sure how it comes into play, but it's a good reminder to sort of inquire as to why an employee is requesting the leave. Obviously, you've got the FFCRA to consider if somebody requests leave. That's the new federal paid leave law that allows employees paid time off under certain circumstances. You've got the regular FMLA and the ADA. The ADA could be implicated with employee leave requests if you get someone who, says, I can't come back to work. I've got an autoimmune deficiency and I'm at high risk. And here's a doctor's note saying that, that person could be entitled to, an unpaid leave of absence as an accommodation under the ADA. So again, these are sort of, and then company provided leave and workers' comp or other issues. But these are all kind of things that should be in your decision tree when you're deciding whether or not to return someone to work. And consult with legal counsel if it's tricky. I'm seeing a lot of kind of vague, questionable doctor's notes out there. A lot of questions about what happens when the doctor just says, we advise this person should quarantine, and there's no specifics. And so there's all types of issues that can come up, and think through those carefully. I've got the link up there to employees that are wanting to stay on unemployment even after you've offered them, made them a bona fide offer of employment. You can report that through that form to SCDO. I think the very last thing is on PPP funds. And if you are involved in the decision-making process around and PPP funds, this is the Paycheck Protection Program. It was a very large part of the federal stimulus, which provides forgivable loans to businesses. If you've never heard of this or you have no idea what's going on, that's fine. But if you are involved in any PPP decisions with your organization, reach out to us if you're trying to make a determination on whether to keep or return those loan funds. You've got until tomorrow to return the loan funds if you're going to. We got some new guidance through the Treasury Department as of 10:30 this morning on that. So if you're involved in those decisions, feel free to reach out to us. Even if you're not involved in PPP decisions, go ahead and inquire of other management in your organization to ask and see if you have applied and or received PPP funds. And the reason I say that, I'm not trying to put more work on your plate, because I know you've already got enough to do, but some of the decisions around use of the PPP funds are going to be closely tied to what you do as HR. So the forgiveness of the PPP funds is all based on your maintenance of headcount, the number of jobs you have, as well as maintaining compensation at pre-COVID levels. And so when you're making decisions about bringing employees back, laying off employees, doing it in phases, you've got a certain amount of time to spend the funds. 75% of the funds have to be used on payroll. So there's all these kind of decisions that are tied up in using the PPP funds that, HR is going to need to be consulted on. I think you need to be relatively up to speed with all that. And if you're not, it potentially could impact your forgiveness under the program. So if you've got questions about that, feel free to reach out to us. With that, I know we're 10 minutes over our 1 o'clock, but it was a lot of information. Some of it we moved through pretty quickly, but I know that you have access to the slides to sort of go back and digest some of the information. Chris, did you have anything from the Q&As or anything else that you want to see? We got a PPP question, which I will. There's a question about why would we return PPP funds? Good question. The Treasury Department has basically come out and said, when you apply for PPP funds, you have to make a certification that due to uncertain economic conditions, the loan is necessary for your business. And initially we thought that kind of meant everybody. And then the Treasury Department came out and said, no, if you've got access to other credit, if you've got cash on hand, if you're a liquid business, this program really ain't designed for you, and we're going to give you an opportunity to return the money or else, kind of. And it was really scared and confused a lot of people. And so the Treasury has, said, look, if you don't need the funds, return them. And so there's been a lot of confusion about, am I really eligible for the program? And we got some updates this morning on that. So reach out to me if you need more information on that.
And I have nothing else to add. Thank you, everyone, and stay safe.
Thanks, everybody.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.